the stakeholders. They're not supposed, it's only for members.
Right, I'm saying we're live now.
Good evening and welcome to the Racing and Gaming Subcommittee session, on House Bill 940. Today is March 3rd, and for those members of the subcommittee returning for the second session today, welcome, and I'm delighted to know you're back with us. What we're going to do today is the subcommittee has participated in a public hearing and two work groups on Monday as well as earlier today, and we've certainly garnered a lot of information. And I want to thank our analyst George Butler, who's worked with us through legislation again and again by providing further explanations on key areas, topics. He answered questions and provided supportive documentation, including the documentation that was requested earlier today as it relates to minority participation. The recent copy of the regulations and other information that we have will help us, aid us in making really conscious decisions and voting on legislation that will impact this expanding industry. I'm very appreciative to the stakeholders who provided oral as well as written testimony, and the fact that they are participating outside of the Zoom meeting today surely is a testament to their observation that we listen to them. We certainly appreciate their input and know that we're all in this together. But most of all, I want my colleagues to know that as we go through the legislation and amendments and other considerations, that we know that all of us are fighting for our districts and advocating for the districts that we represent. I want to also thank the speaker for sponsoring this bill. As such, this legislation represents the impact that the expansion of sports wagering, sports betting will have on the state and the potential revenue that will be generated. And in addition, most of all, it will provide opportunities at various levels, various businesses. And for that, Madam Speaker, we're very appreciative. All right, so that's my introduction. And in terms of where we left off, we have, we have to wait, I believe, for a few more members, but I do want to say that they will be coming in later on. We know it's 6:30, and so we will proceed. I think we had most of the areas of concerns covered. George, are you able, was there something we left off, or do you feel that, were there any other questions relative by the members here to overall HB 940?
I'm sure I believe that we provided a pretty thorough discussion of a number of the issues that were raised in.
We can't hear you, George.
I believe, Madam Chair, that we have discussed quite a few of the issues that were raised both during oral and written testimony by the stakeholders. We've discussed a variety of issues ranging from eligibility for licenses, the numbers of licenses, where general regulation of the industry, including acceptable wagers, those are not acceptable, how to address concerns raised regarding those wagers or betting types. We've discussed a number of the monetary aspects related to the industry with respect to application fees, the tax rates, things of that nature. So we've discussed a number of concerns regarding minority business equity in the industry, both in the form of the procedures that will be done in
How much do I?
evaluating the
10, 15 bucks.
disparity study that was previously conducted, the future review of applications, and minority participation goals that licensees will be subject to. With that, Madam Chair, I believe that you could ask if any of the members have any remaining issues that need to be resolved.
Absolutely. I'm looking for, oh my gosh. I'm not sure if I see a hand. I don't see any hands right now. So
Madam
we'll,
Chair, I don't have any questions, but if you'd like, I think Delegate Barnes and I have a series of amendments based on the input that we'd like to sort of walk through and propose to the subcommittee.
well, that's very timely, because what I was going to say is that there were several concepts, a lot of amendments that were sort of grouped together, that these items were brought to the committee. And so let's look at the one that, one of the issues was the issue of problem gambling. So I know that was an issue of concern offered.
Yeah, Madam Chair, do you mind if I jump in and sort
Oh,
of describe
absolutely.
what I suggest we do? So we're working on a series of amendments trying to incorporate a lot of the discussion of the subcommittee, a lot of the input from folks on problem gambling in particular. A number of organizations came in with recommendations related to problem gambling. There's two in particular that I think we're working to incorporate into amendments. One would expand the purpose of the problem gambling fund to allow those funds to be used for treatment and prevention programs related to fantasy competitions and sports betting and other forms of online wagering in the state. The second would allow the State Lottery Gaming Control Commission to adopt regulations concerning fantasy competitions that include establishment and creation of a voluntary exclusion list like we have for the casinos. So the voluntary exclusion list, a person who is having challenges managing their addiction voluntarily signs up to be excluded. So this would be a voluntary exclusion list for sports betting and fantasy competitions that any of the licensees, brick and mortar or online, would have to comply with.
Right, well, that more or less covers what we had heard before, and I appreciate the amendments that you provided conceptually for the committee to consider. Are there any questions relative to Delegate Lukey's comments regarding amendment comments regarding problem gambling, problem gaming?
I think those are sensible amendments. I make a motion that we accept those amendments.
The
Second,
motion, is there a second?
second.
All right, any discussion?
Well, hold on. I think
I think it's
we're all trying to talk, Delegate Rosebuckle
Which-
Hornberg.
No, so I will tell you that because of some technical difficulties, the Republican members of the caucus have formed our own cabal. We are all located in one location on one computer. And
Sorry.
we are eating our dinner while participating in this meeting all at the same place. So
looks good.
Rose and Delegate Hornberger is more hungry than what he is participatory at this point in time. He is here. I'm physically touching him as we speak.
We're good with the amendment.
Yeah, I don't think we have any problems with these amendments about the problem gaming fund and expanding it to fantasy sports or fantasy sports related situations.
Well, great. Thank you for all those in favor.
Aye.
Great. Thank you very much. The other area had to do with banking. And the banking, I think is banking of the Bank Secrecy Act. And in terms of alterations with, I believe it's with fantasy gaming operators. That was one of the concepts.
If I may, Madam Chair,
Yes.
the State Lottery and Gaming Control Commission raised a concern regarding the inclusion of references to the Bank Secrecy Act and both the definitions of fantasy competition operator, as well as a new definition of gaming establishment, which is a term that is used in the subtitle concerning sports wagering for purposes of information sharing, I believe, related to enforcement of federal law. A similar change was made with to the definition of video lottery operator in recent years for similar purposes.
Madam Chair, I'd like to move that amendment. It seems largely technical to make sure we're complying with the Bank Secrecy Act.
Second.
All right, you've heard the moves and second. All those in favor, any kind of discussion?
Aye.
Aye.
All those in favor, aye. Thank you.
Aye.
I want to be where you all are. All right.
Gotta set a
Okay.
technological box.
Okay, now let's consider fees. George, do you want to have a conceptualization of some of the fees as it relates to competition fees?
Sure. Madam Chair, the Lottery and Gaming Commission in a separate conversation raised concerns that the proposed registration fee under subtitle 1D might be prohibitive to the point where existing registrants may no longer seek to register with the commission. It was suggested that the fee be reduced or stricken.
Madam Chair, I move that we strike the fantasy competition registration fee.
All right,
And this relates only to the fantasy gaming operators, right? That's
it's
the
only
section, right?
fantasy, right?
Yep.
Only
Second.
fantasy gaming.
Yep.
Second.
All right, it's moved in second. All those in favor, please vote by saying aye.
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 Thank you. Those opposed? Thank you very much. It is unanimous for this. Okay. Moving right along, there are some definitions, technical or just definition clarification as it relates to sporting events and some other proceeds. Section D1. George?
I
Madam
believe the
Chair.
Delegate Lukey might
Okay,
be
Delegate.
able to
Lukey.
discuss this matter.
Okay.
Yeah, Madam Chair, thank you. These are just some technical clarifications that do have some substantive impact. They would expand the definition of a sporting event to include award events or prominent competitions if authorized by the State Lottery and Gaming Control Commission. They would also clarify the term proceeds, and the changes there would allow, as we do for VLT licensees, it would make clear that promotional play is not part of what's taxed. So I would move that amendment.
All right, is there a second, please?
Second.
Thank you. You've heard, it's been second, although in addition.
Recruitment players.
I think Delegate Buckle might have a question. He looked like he.
So, no,
All right.
my only question was, you said we're going to expand the definition of sporting event. What's an example? I mean, I'm generally in favor of that, but just so that I can answer that question, if asked later, what's an example of what we're talking about expanding that to?
Delegate Buckle, if you'll recall, the referendum that was passed earlier in the year referred to permitting betting on both sporting and other events. These events might include, say, an awards competition, such as the Grammys recently held, or the Oscars, or things of that nature. I think you would have the commission weighing in on these types of events prior to wagers related to them being able to be accepted.
Okay, that makes sense. I mean, as long as the commission will have the ultimate discretion over how to do that and why and when to do that, that sounds fine. Does that sound fine to
Mhm.
my colleagues here, to my left, to my right? Yep, thank you.
All right, I believe we had the vote on that. All in favor, it was unanimous.
Right.
Aye.
Also in section, thank you. In section 9, the MBE Minority Business Enterprise clarification of the intent of the Maryland General Assembly.
Madam Chair. This
Expert is
basically-
Delegate Barnes.
Thank you, Madam Chair. Yeah, this basically clarifies that we want to maximize the ability for minorities and women to participate in the sports betting industry through the ownership of licenses.
All right, so it's just a clarification, the amendment that you're proposing.
I need to read that out.
I second.
Is this in the preamble portion of the law, the uncodified section, or is this something, George, that's in the codified section that says it's a general intent
Yeah,
for?
it is in the codified section, sir, under 91E02. If you'll recall, there is a declaration of intent by the General Assembly that the subtitle is to be implemented in a manner that, to the extent permitted by state and federal law, maximizes the ability of minority and women-owned businesses to participate in the sports wagering industry. This would clarify that it would maximize the ability of minorities, women, and minority and women-owned businesses to participate, and also makes clear that participation would include ownership of entities that are licensed under the subtitle.
Are we, by doing this, I mean, we're making the intent that participation, we would prefer, participation would mean ownership, equity.
That's correct.
But we're not mandating that. And the only reason that I ask is because, as you all know, as I've expressed several times, my number one objective is to make sure that whatever we do doesn't get thrown out by a court somewhere. And so we're expressing that's our preference, that equity would be the way through which minority-owned businesses would participate, but we're not mandating that so that we're perhaps getting afoul of what the disparity study would necessarily lead to.
You're spot on.
Okay, that sounds good.
Okay. All those in favor, please vote by saying aye.
Aye.
Those opposed, nay. All right, again, it is unanimous. Thank you. Okay, we're moving through, believe it or not, we are moving through the bill, the document. Section 9(1)E has to do with administration. The requirements of the State Lottery, Gaming and Control Commission. There were some suggestions or issues or concepts brought forward regarding the administration.
And I will ask.
Delegate Loki.
Yeah, thank you, Madam Chair. I think this one, I believe, came from the Lottery and Gaming Control Commission, so I'll ask George.
The amendment did not necessarily come through the commission. However, it is intended to address concerns regarding costs of administration related to some aspects of the bill. And the amendment would require the commission to consider, doesn't say that they must, but they have to consider the use of technology, including remote surveillance, which I believe is used currently with respect to or by the Racing Commission with respect to OTBs for their activities or other similar measures to carry out their duties under the subtitle.
To ensure that betting is being done above board. So
and so as to potentially avoid having to have in-person monitoring, which is currently what they do with respect to video lottery terminals and table games, I believe.
In other words, Madam Chair, without this amendment and without the Lottery and Gaming Control Commission thinking about this, they would essentially have to have staff on site at every physical licensee at all times, and that could be cost prohibitive. So I move the amendment.
Or second.
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 Thank you very much. You've heard the amendment that's moved. Second, all those, any questions, please? Don't see any questions.
No.
All those in favor, please vote by saying aye.
Aye.
Those opposed, nay. Again, thank you for the motion carries. We talk about this almost every time, prohibited wagers, because not what prohibited wagers. And again, it deals with the requirements placed by or on the State Lottery and Gaming Control Commission. So, George, you want to provide more information, or is it?
Certainly, Madam Chair. There were
Yes.
concerns raised regarding player well-being or safety that concerns have been raised both last year and this year regarding the prohibition of wagers about injuries or penalties or things of that nature. I believe that the point is you would want to you'd want to prohibit wagers that are unfair or would be against public policy.
Okay, so the request is for an amendment to have support or the requirement for the State Lottery Gaming Control Commission.
Yeah, can I, George, just to be clear, this is also the amendment that, I mean, it specifically includes language about injuries and penalties, or it leaves that open?
One moment. It does the language of the amendment would specifically refer to wagers on injuries or penalties or other types of wagers that would be contrary to public policy or unfair to the bettors themselves.
Okay, so this would, colleagues, among other authorizing the Lottery and Gaming Control Commission to determine that a certain type of bet was contrary to public policy, it would specifically ban betting on player injuries or penalties, which seems to me like a reasonable thing to do. So I move the amendment.
Second.
All right, thank you very much. All those in favor, please vote by saying aye.
Aye.
Whose hand is that?
That's Kevin.
Hornberger.
All right, thank you very much. The motion carries. Okay.
Whose hand is that?
Going back as we continue through the bill, going back to MPEs, section 1E-4. Again, the requirement for the State Lottery and Gaming Control Commission to use in a sports evaluation responsibilities to review studies. So as you know, Delegate Barnes, I always come to you or George for, George, you want to address why this was a concern? Yes.
Yeah, so Madam Chair, this amendment strikes the requirement for the Lottery Gaming Commission to evaluate the study of sports wagering. And it allows the SWORC, if you will, to consider methods to address needs of minorities, women, and applicants, and minority and other businesses seeking to participate in the industry.
And again, that was offered as from many stakeholders as a way of addressing or clarification for MBEs. Any discussion?
So I guess, Chair, my only question, I guess, is that been vetted or analyzed by, the people who are far more experts than certainly what I am, as to whether or not, again, that would present a potential stumbling block, legal challenge to say, well, lottery and gaming didn't implement the results of the study or view it through the prism of the study. They just presumed that MBE participation was mandated. And I may not be completely understanding, Daryl, what the amendment is, but that's what I thought you said for the first sentence, is we're removing the language in the bill that says that lottery and gaming will review the study.
Madam Chair, if I may interject.
George, I was going to say, why don't you wait?
So if you'll recall, the language regarding evaluations of the disparity study is actually, it incurs in two places. One, first with the Lottery Commission, second with the Sports Wagering Application Review Commission. The Application Review Commission is the one who's going to actually review the study. They'll be consulting, they'll adopt regulations that are going to govern the review of applications related to it. It's not necessary for the commission to also review the study.
We're just cutting one of the two of them out.
Exactly, that is correct.
Okay, that makes more sense. Thank you.
Second
Thank you, Delegate Buckles.
Yep, that's fine.
Okay, any other questions? All those in favor, please vote by saying aye.
Aye.
Opposed, nay? The ayes have it, thank you. Okay. For that same category, there was a discussion or consideration regarding waivers and the clarification that's needed by the State Lottery and Gaming Control Commission.
Right, so Madam Chair, this
Yeah.
amendment clarifies that the State Lottery Gaming Commission may not grant an exception to a licensing requirement adopted by the SWART to implement remedial measures.
So it's clarifying legislation.
That's correct.
Any questions? Okay, all those in, is there a motion?
So move.
Second.
Thank you very much. All those, any discussion? All those in favor, please vote by saying aye.
Aye.
Opposed, nay. All right, thank you. The motion carries. Moving through the bill, another clarification role has to do with Sports Wagering Application Review Commission.
Right, so Madam Chair, this amendment basically clarifies the role of the SWART to award licenses, and the State Lottery Commission is to issue the license.
Okay. Any questions regarding that? Again, it's clarification. Is there a move?
So
Motion?
move.
Second?
Second.
Thank you very much. Any discussion? In favor, vote by saying aye.
Aye.
Those opposed, nay. The ayes have it. Okay. Another clarification that was brought through the stakeholders and also through reviewing or reading through the bill has to do with the subsidy of state fair eligibility for the state fair, license eligibility.
Yeah, Madam Chair.
Timonium, yes.
Yeah, so the language regarding the Timonium license, we need to clean up to clarify that it's actually a subsidiary of the State Fair Society that will hold the license, not the State Fair Society itself, which is similar to how the OTB license is currently held by Timonium. And also to clarify that wagering would be conducted at the fairgrounds in Timonium. So this is essentially clarifying language for Timonium. So I'd move the amendment.
Second?
Second.
Is there a second? All right, thank you. All those, any discussion? All those in favor, please vote by saying aye.
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 Those opposed, nay. Okay. For Timonium, I have a bill before us. Excuse me, and it's, I'm sorry, an amendment, not a bill, an amendment for an expansion license eligibility expansion to include Class A license for the riverboat, which is located in Charles County. The idea, the amendment is that Riverboat is certainly historic. It has been in Charles County for a number of years. It sits in a very unusual way. It's right on the Potomac, the riverboat itself. However, it is located in Maryland. And because Charles County has rights to the Potomac, any revenue that will be generated from this establishment would in fact go to Charles County and to Maryland most of all. But the people who would be attending or having bats at this facility are largely 90% from Virginia. There's a Dahlgren Naval Base and Fredericksburg, et cetera, close by. And we know that there is an interest in the gaming industry. It is a minority-owned business that will also meet the requirement as we talk about diversity. So I am proposing an amendment to authorize the Riverboat OTB to receive a Class A license.
Second.
So move.
Move the
Can
amendment.
we comment
Is there a
on
second?
the comments on the amendment?
Yes.
Hold on.
Do I see a hand? Is there a question?
Delegate Rose, your computer is glitching out a little bit.
Okay. Is the ownership of going to the operator? Oh, it just died. Or is it going to the owner of the riverboat?
When you say, I'm sorry, is it the carrier?
Type it in the chat.
Yeah, is the license being granted to the owner of the riverboat or the operator of the riverboat? Because my understanding is they're two different entities.
Well, looking at the amendment, George, you have it before you. It is it is owned by a diversity industry. So I'm unsure what it is you're asking. Is the owner a minority or what?
He's asking, because there's a separate entity that owns it versus operates it. He's asking which of them will be the actual license holder.
Be the license holder of the simulcast permit.
Okay, so it
The license holder.
yeah, so the license holder on this amendment, Delegate Hornberger, would be the same entity that holds the current OTB license there.
Okay. And then just kind of an aside, can you list the entities that will be getting these guaranteed licenses? So right now we're at Timonium, the Riverboat. Is there another entity?
The Jockey Club,
Jockey Club, okay.
and then the 6 casinos.
Okay.
Any other questions?
So, if I may, Madam Chair, Madam Chair, my only concern is I certainly appreciate the riverboat, the presentation that they made. And I know that the impact that it can have for Charles County and for your community. Is there a concern that if we specifically identify in the bill one off-track betting operator, existing off-track betting operator, to automatically get a license, a brick and mortar license, that will perhaps cause problems with other OTB licensees, some of whom may also be minority owned or may with MBEs for equity ownership. If they don't get licenses, they will then sue on the grounds of what is the rationality of the legislative scheme that identifies one OTB with minority participation to get a license and does not identify others. And what I really want to avoid is we saw much of this, obviously, as you and Delegate Barnes and all of us are familiar with, in the medical cannabis licensing scheme, where licenses were selected in certain ways that later necessitated lawsuits about what the rationales were And so I'm very supportive of the Riverboat, and I thought they made a wonderful presentation, and sports gaming would be a natural fit for what they do. But I did want to simply say that if we're just picking one of the OTBs for a Class B license, and then making everyone else similarly situated go through an additional process, that may in fact open up some legalistic concerns. I don't know if anybody else thought about that, or if that's a
Well, that's a consideration, but I think in terms of the riverboat, it serves a unique purpose, and that many others do not. As I said before, it's locale, it's potential for the increase in revenue, the fact that it has so many of the criteria that we're seeking and looking for. This is, I think, an opportunity. We didn't put in geographic location, but in essence, in terms of fairness, I think that is a consideration that this committee should really think about. And so when we think of Southern Maryland and we think about the fact that it has been there, it has its history, I think those are multiple factors that are, I believe, defendable. Any other questions?
I appreciate that.
Delegate
Madam
Smith?
Chair, Delegate Smith has her hand.
Yes.
Thank you, Madam Chair. I just wanted to, first, I want to thank Delegate Buckle for the question, because I think it's a fair question. But to the chair's point, we basically created a rationale around Class A that I think kind of holds true for why you would, under Class B, think of this site as situated in a unique fashion. I know there are going to be a lot of other folks approaching an opportunity that maybe do not have that same grounding in a similar concept and experience and set of analogous technical and back-end, capabilities and functionality. So I think it's like, once we start having that conversation, it could be opening Pandora's box back to like, well, then why do we have designated places for Class A? I think the ultimate goal here is that we want to make sure we have an inclusive opportunity. And we know that, yes, it's an emerging sector, but there are going to be some existing businesses that are either more readily just kind of like, I don't know if the word I'm searching for. I've literally eaten nothing today, people. Nothing. This is no food, no caffeine. I'm just doing my best right now. But there are just other, kind of sectors that are more turnkey. I guess it's like the phrase I'm trying to think of in terms of having analogous analogous kind of functionalities around what the business models are. And we recognize that, and that's why we've done what we've done with Class A. But I think to Class B's point, that I don't think there's a rival of the Riverboat in terms of what they're offering, in terms of background, expertise, and then also helping us to fulfill the intent and will of the speaker and creating an inclusive, market. So I just wanted to give, I do believe Delegate Buckle, that's a fair question, but I think, there are ways that it could be defensible. But as an attorney, the answer is always, it depends. You can always find a way to make anything true. And I believe that it's defensible as well.
Thank you very much, Delegate Smith. Delegate Lukey? Lukey?
I think we just,
Hand up? Yes.
yeah, we just lost Delegate Buckle and Delegate Rose and Delegate Hornberger.
They'll come back.
You want to wait a second for them to
And
log back in?
Yes.
Here they come.
Okay.
Can you all hear us?
Yes. Yeah,
We had a
intermittent-
internet thing.
Gotcha. Okay, so we waited. So-
We're halfway there.
Yeah, I didn't. So to Delegate Buckle's point, I appreciate his point. I do think this is a separate issue from others in sort of the same license class in terms of OTB simulcasting facilities because of its geographic situation. First of all, it is, as you know, connected to Virginia, and one of our goals with this bill is to maximize revenue to the state. And what better way to maximize revenue to the state than to have, wealthy Virginians gamble in a Maryland sports betting facility attached to their shore. And the other aspect to it is, bluntly, one of our goals has been to try to make sure there's MBE opportunities here. This would be the only Class A licensee that's an MBE. So I support the amendment.
If I could, will this change, or should we possibly think about, because if we're specifically awarding one of the, which my understanding now in our current iterations, if we are specifically targeting one and writing it into statute as we're granting it to the riverboat outside of the evaluation commission process, would that mitigate in terms of adding an additional license in that Class B field, so that the other, I don't know how many, none of us know how many, there might be dozens of other applicants still have that same opportunity from a numeric standpoint that they would have had before we began the process?
So Delegate Barnes is gonna, I think, have an amendment in a little bit, increasing the number of Class B licenses available.
Okay.
Thank you for those points. Was there a second to the amendment?
Second.
All right. All those in favor, please vote by saying, raise your hand, please.
Because
Jason raised his body. All those opposed? No,
Are we ready? No.
I can't discern.
Good.
Is there anyone opposed?
Just say no.
Are there any opposition?
Is there any opposition? No.
no, I'm sorry,
No.
I stepped away from our group.
You raised your body.
All right, thanks.
I raised.
All right, thank you very much.
Yeah.
Thank you for that and for those questions. All right, we are halfway through. In terms of, again, license eligibilities, the question has concerning different establishments. Let's consider.
So, Madam Chair, I'd like to address the amendment to authorize stadiums of in-state or professional football team or minor or major league baseball teams to also receive a Class A license to be used during game day or during large events.
All right.
Second.
Okay. The motion has been made, second discussion. Okay, I don't see any hands. All those in favor, please.
Just again, because we don't have it right in front of us. I just
Oh, I'm
want to
sorry,
clarify.
I'm sorry.
No,
Delegate Buckles?
that's okay. It's our fault. We are morons who brought one laptop and too many pizzas to a nighttime voting, which we've never done this before, so
Too
hopefully
many
we'll never ever do it again.
pizzas? Okay. All right, did you have a
Yes,
question?
Pizzas, 3 laptops. So Delegate Barnes, my understanding then is we'll say that anyone that has a professional sports team operating in the state of Maryland would get a license just for, now your screen's up, just for the, I'm sorry, just on game, is that right?
It's game days plus large special events like concerts, and it would only be major league teams.
Do me a favor. Go hit the button on the modem.
Lose
See
them?
if I can connect. I think we're fine with that amendment.
Okay.
Behind the TV. You know what? Behind the TV, there's a button on that modem.
First fucking call COVID-19 at this point in time is about the chance of me calling joining the NBA. So we're gonna do it this way.
Can you guys hear us?
They're in a little caucus.
Yeah, they're just trying to figure out their internet connection, I think.
Okay. Can you hear us?
Yes,
Can you
Yeah.
hear us?
yes.
Yeah, the
and see
connection's a
you.
little shaky.
Okay.
Can you tell me what we're having so many problems? What are we voting on?
So
Sorry.
the amendment states that we are authorizing owners of stadium
Okay.
in-state or professional football teams or major league teams to receive a Class A license to be used during game day or during large events.
Do it yet. Okay, we'll go with that. Yes.
Yep.
We're all good.
That's good. All right, then, the vote, I believe, is unanimous. Thank you very much. And Delegate Barnes, you want to continue with information or a motion regarding Class B license?
Right, so Madam Chair, I'd like to increase the number of Class B licenses from 5 to 8.
Can I ask if we can get one?
Okay.
Second.
All right. Yes, question. Delegate Rose?
Just a question on from 8. And again, as I've stated before, I would prefer more opportunity across the state. So is there any consideration to make it more than 8? Could we go to 10? I mean, again, just, if the goal is to bring in more money to the state, I guess the philosophy of why we're limiting it, I still don't completely understand. And so I'm just throwing that out there as a consideration.
So these are the Class B licenses. And so your suggestion is to go from 5 to 10 versus 5 to 8.
Yes, just mainly because as we heard last year, there were 5 OTBs in the state already. And so if we were going to increase that participation, I think just for, to double it, to me makes sense. But that's just, that's my suggestion. I would just like to see more opportunity for, the small businesses to be able to try to have a chance to participate in this.
Any other discussion?
Any other discussion?
Well, I guess my question would be, so the Class Bs, as I understand it, are the unallocated licenses. So Class As are places that we're already saying, except for now the riverboat. So the riverboat is going to get a Class B.
We're getting a Class A.
Okay, so all of Class B will then be the unallocated licensees,
Floaters.
Correct.
and we want to move that to
George, do you want to weigh in on this? Okay.
As Delegate Buckle noted, the Class B licenses would be competitively awarded to authorize in-person betting at the various facility locations. And generally, there's a radius regarding how close proximity they can be located to each other and other Class A facilities as the bill's been introduced.
So it's 10 miles, right?
All right, Delegate Barnes, it's your amendment. Or other discussion, Delegate Lukey?
I was just going to say, Delegate Barnes, I'm fine with either 10. I'd defer to you as the maker of the motion.
We always want to make April Rose happy because she's my friend.
You want some pizza? Delegate Rose, does that work in terms of your interest from 5 to 10? Delegate Rose?
Yeah, I think, yes.
Okay.
Yes.
All right. I second the amendment.
All right, thank you very much. Any other discussion? All those in favor, please vote by saying aye.
Aye.
Okay. And I believe this is unopposed. Okay.
Madam Chair,
I'm going to abstain on that vote, to be honest with you. I've never done that before, but I'm going to abstain just simply because it's only going to work for me if we're tying the Class A and Class B licensees brick and mortar to their ability to have a mobile license. If we're just creating all of these brick and mortars and they're not going to get, I love my friend sitting a foot away from me, Delegate Rose, but an OTB, a mom and pop OTB, just gets a brick and mortar license and doesn't get a mobile skin, it isn't going to work.
The big boys aren't going to want to come in and pair with them, and they're not going to be able to afford all of the infrastructure that goes into this. So to me, it's an apples and oranges, or which, putting the cart before the horse, whatever analogy you want to lose. So I'll abstain until we get to the point where we can discuss whether mobile can tie in to brick and mortar. Thank
Well,
you.
that's next on the list. So you're right on target. With the mobile license numbers, Delegate Barnes.
Madam Chair, my amendment states that we want to increase the number of mobile licenses from 10 to 15.
Was that good or bad?
Motion is to Delegate to Hornberger. Delegate Horn.
I just wanted to, yeah, thank you. Last amendment that we just passed, there are some concerns about the proximity of one of the licenses to the brick and mortar casino. I didn't know if now is the right time to talk about that or later. So this is the physical distance from a Class B in conjunction to a Class A.
Madam Chair, I can maybe answer that.
Okay.
After the number of mobile licenses discussion, I think there is a conversation we need to have about the radius. There's an existing exclusive zone around some of the licensees. In the original bill, it's 10 miles. I think that probably needs adjustment. But Madam Chair, what I'm going to suggest to you with that particular provision is I think we've got some more conversations to have and some more work to do about that. So I think that provision, at least that part of the conversation, should be held over for a conversation tomorrow or Friday in subcommittee.
That's fair.
The Class B radius. Okay.
The radius, yeah, the radius around licensees.
Okay.
So Delegate Barnes, your amendment is to increase the mobile licenses from 10, is my current understanding, to 15. But it still doesn't address or doesn't provide within the amendment to tie the brick and mortars to the licenses, right? So we could wind up with more than 14 brick and mortar licensees, now 7 Class A's, plus the racetracks, plus 8 Class B's. So you'd wind up with more than 15. And then you could, in theory, have 15 mobile licenses, and some of them may be very different. They would just be freestanding or floating mobile licensees without any actual brick and mortar presence in the state. What's the rationale for increasing the mobile licensees if we're not going to tie them in whole or in part to the brick and mortars?
So what is your idea of tying them into the brick and mortar?
Well, I mean, I think, Delegate Barnes, that it's important both casino operators who have that ability, to my knowledge, in every other state where they have a sports gaming license, they also have a contemporary mobile license. And I also think, and you and I have discussed this before, I happen to think that it's very important, if we want to have a successful minority business that has a brick and mortar license that qualifies for one of the Class B, in order for them to be successful, I think a lot of people who study the industry believe they also would have to have a mobile application, so that someone who's a startup minority business that wants to get into this space and says, hey, I'm going to go out and take loans and do things to maybe open a business or expand an OTB, whatever it may be, they're going to need the expertise and probably some of the capital to pair with a mobile operator in order to make this financially viable. I don't want to see any of the businesses fail. I want to see them. I think it is a little bit different than medical cannabis, which has lower barriers to entry, and we very strictly defined geographically. Mobile app, obviously, you could be using a mobile app anywhere in the state. We're bringing people across state lines as long as you're geo-fenced. We all understand that at this point. And so I want to see those businesses succeed. I think they have a much higher chance of succeeding if we pair them with a mobile license, rather than just having companies coming in, applying for freestanding mobile licenses that may, in fact, then undercut a minority-owned business that gets one of the Class Bs for a brick and mortar, if that makes sense.
It does. Here's my general philosophy around the increase of mobile and the increase of Class B. At the end of the day, I've said, and everyone knows that my true intention of this bill is to provide opportunities for minorities to participate in yet another multi-million-dollar industry that's coming before the state of Maryland. Looking at the lessons learned in medical cannabis and trying to make sure that we apply those lessons as best as we can with this sports betting, the increase of licenses for Class B gives minorities an opportunity to once participate in this industry from a brick and mortar standpoint. Looking at the number of Class A licenses that we have, it now, with the increase of mobile licenses, it now gives those minorities an opportunity to obtain a mobile license as well. I am just not in the mindset or inclined to pair a Class B 51% owner to a casino because the casino is already has a Class A in which we're writing in. I'm sure that they're going to put together an award-winning application for a mobile license. And such should they pair with a Class B, and in my opinion, they're double dipping for that opportunity. My objective is to try to make this as fair as possible and have folks compete for these licenses, because as we know, there are multiple people from around the state and other organizations that are vying or would love to get an opportunity to obtain one of these licenses. So my thought was, is to make it where it is competitive to go after these licenses for the mobile to give everybody an opportunity, because we know that's where the real money is.
And I appreciate that. I mean, you've been on the committee, good friends for years. I appreciate that. I just have, I have intellectual heartburn, let's call it, about setting up a situation where a commission, much like what happened with medical cannabis, they may come back 3 months from now, a year after, maybe, and we always say the law of unintended consequences is absolute and brutal. And, we may wind up with a situation where you have someone who was able to secure a Class B brick and mortar license as a minority, also perhaps securing a mobile license. And if they don't get the mobile license because for whatever, maybe they don't have the technology, maybe they aren't partnered. These are very specialized things. You guys know that I'm terrible at technology. We've demonstrated that tonight. I certainly couldn't create my own online sports gaming app, but the fact is hardly anyone can. I mean, they're not ubiquitous because they require a lot of capital and a lot of upfront effort. And so that's my fear, is that we give someone a Class B license, brick and mortar, they come in and say, that's wonderful, but I didn't get a mobile license. And as a result, I'm now operating something that really isn't worth all the regulatory fees and the other. It's going to be worth it for the casinos because they're in the gaming business 24/7, 365, and they have all the ancillary gaming streams involved. But if you and I wanted to start our own restaurant with a sports book in whatever town, Maryland, if we didn't have a mobile app to tie to it, I don't think that we would look at each other as businessmen and say, hey, this is going to take off. We're going to get rich. I think there would be some flaws. So I appreciate those considerations. I don't know if the committee feels like, we have to move to 15 right now. I have no problem with 15 as a number. I just think that we're creating a lot of different classes of licenses that won't work in the real world unless they're integrated together. That's all.
Okay. Delegate Lukey.
Thank you, Madam Chair. I appreciate the thoughtfulness of the comments. I happen to disagree. I think the idea that a physical sports book can survive without a mobile arm to it is belied by history. The UK has had physical sports books for generations. and they have survived and they've stood the test of time, and the people that own them have made plenty of money. So I don't think, I don't necessarily buy the argument that you must have a mobile license for every physical sports book. And I also, I associate myself with the comments of Delegate Barnes. I think the way this is built, increasing it to 15 will, maximize the opportunity for an MBE-owned mobile sports book to take multiple MBE-owned mobile sports books to take off in the state. So Madam Chair, I would second the amendment, and I support it.
And let me just say real quick to Delegate Buckles' point that I totally agree that we don't want to set these businesses up to fail. And the last thing that I want to see is that, we have hundreds of licenses out there that people truly don't qualify to obtain. And my hope is that this commission that is reviewing these applications are actually looking at things in which to determine the qualification of such applicant to ensure that they meet all the necessary requirements to obtain the license to ensure their potential success. So I think the number makes it competitive. I think the number makes it fair. I think we've increased the number to show that we want more people to participate. I just think we're doing it in a way where those that qualify will be able to have an opportunity to obtain a license. Thank you, Madam Chair.
Thank you very much. Thank you.
Question, Madam Chair.
Yes, I'm sorry. Delegate Hornberger?
Thank you.
Okay.
So I just want to put it in perspective of we'll speak for the three smaller casinos, one of which is located in Cecil County.
Mhm.
They get a brick and mortar license, no problem. That's fairly straightforward. And then they seek to get a mobile partner, an additional ad hoc, whatever you want to call it, license. What does that process look like? If someone could explain that.
So what is your question once again? I'm sorry.
So if I am one of the smaller cohort casinos,
Yep.
Rocky Gap, Ocean City, Cecil County, I buy in and I get my brick and mortar license. I additionally want the mobile because ultimately that's where the money is.
Mhm.
And how do I procure up the odds of getting the license?
You broke up there a little bit at the end, Delegate Hornberger, but I think what you're asking is how do you go about getting a mobile license if you are the casino at Perryville? And they could apply,
Or
they could develop a subsidiary partnership with minority equity owners, and perhaps get, if the SWARC, as I think they likely will, gives extra points to companies that have equity ownership from MBEs, then they might get those extra points. Or they could develop a partnership with some, one of the big, national or international mobile sports betting firms. I mean, they have multiple options for applying for that mobile license, but they would be competing in a free market, competition with everybody else.
Sure. Okay. Thank you.
Okay, the motion has been moved in second regarding the expansion from 10 to 15 licenses. All those in favor, please vote by saying aye or raise of hand.
Aye.
All right, those opposed? No hands. It's unanimous. Did Delegate Buckle, is he abstaining?
No, Madam Chair, you can mark me as having voted. It's fine.
Okay, thank you very much. There, we have some are very simple discussion points. Are you up to continuing through?
I'm fine to keep going, Madam Chair.
All right, thank you very much. I know that Delegate Lukey, you had cited that radius associated with class, but we're going to hold that one.
Yeah,
Hold discussion.
I think that needs more discussion.
Absolutely. Going through the bill, renewal fees, administration of, okay. Delegate-
Sure. So, Madam Chair, this amendment would clarify that the renewal fee, which in the bill as written, the renewal fee varies depending on the gross gaming revenue of the entity in question. It would clarify that it's calculated based on proceeds from sports wagering, and then it would calculate it based on the 3-year preceding period rather than the 5-year preceding period, which is a more accurate representation of where that entity is at the time of the renewal. So I would.
Okay. Is there a second?
Second.
A second for this?
Second.
Thank you. Any discussion? It's pretty straightforward.
Let's carry over this.
Please vote by saying aye.
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 Okay, guys, thank you. All right, application. Okay. Application going to.
So, Madam Chair, this amendment requires the applicants for sports wagering license includes a affidavit requiring minority and women owners and their employees. So basically, they have to put in an affidavit to recognize that they're minority or women owned and the number of employees that they have.
Okay, that's pretty standard, right? George, any comments?
Sure, Madam Chair, the language would be similar to that was required with respect to the medical cannabis industry. Once again, applicants would submit an affidavit with their application that details minority and women owners, their ownership interests, minority and women employees, and then any other information that the commission would require.
Okay. All right, was there a second to the motion?
And is this for, if I can ask, this is just for all of the, I guess, the Class B licensees and the mobile applicants?
It would be all applicants for licensure.
Well, but the Class A's are already getting them automatically.
And you're not going to turn.
So the committee,
They still are going to, the Class A's will still apply for their licenses.
So I guess that's my question then. If we're writing a piece of legislation that says these, however many we're up to now, 7, 8 places get a Class A license, are we then saying that the commission can actually deny them the Class A license based upon other factors? No.
Well, the license holders would still need to meet any requirements for licensure under the subtitle. So if they had any disqualifying reasons that they couldn't hold the license under the subtitle, then yes, a license could be denied. So it's, for example, if there are significant background issues or things of that nature.
Right, I understand. I mean, all the Class A's, with the exception of now the Riverboat and I guess the tracks are all VLT licensees, so they're constantly under supervision of lottery and gaming anyway. But I guess my question is what is the utility of making a Class A licensee complete this affidavit, which all of the casino Class A licensees are publicly traded corporations? So what is the utility of making them fill out something saying what their minority ownership is in order to get a Class A license that we're already guaranteeing them under the law?
If you're a company that maybe hasn't paid much attention to minority owners, that hasn't maybe done much outreach to minority investors, and you do this, figure this out, you file it an affidavit and say, maybe we should try to recruit some minority equity investors to invest, right? I mean, that it's is the way.
Sure, but I mean, they're all publicly traded corporations. So I don't know, and they don't know. MGM doesn't know how many people that own shares in MGM are minorities or not minorities. They just publicly traded corporation.
One assumes they would state that in the affidavit, but the affidavit also applies to employees, for example.
Yeah, key personnel.
Okay.
Okay, any other questions regarding the amendment? Okay, all those in favor of the amendment, please show of raised hand. Delegate Hornberger, okay. I love it. All right, thank you very much. All those opposed? And it is majority, it's unanimous once more. Okay. Okay, we talked about participation goals and the Office of the Attorney General.
So, Madam Chair, this amendment is on the advice of the Attorney General, which revises provision concerning MBE participation and participation goals and procedures similar to the wind industry. So it's clarifying language.
Okay. Move the amendment.
The amendment.
Is there a second?
Second.
Thank you. Any discussion, questions?
We
Yeah.
have just clarity.
Can you just kind of explain this again, just briefly? Because you kind of lost me a little bit there with the Attorney General.
Madam Chair, if I may.
Yes,
Or-
George,
and
please.
Delegate Barnes, if you don't mind if I interject.
Go ahead.
The language that was included in the bill is modeled on video lottery terminal statute. However, during the intervening years, this language has been, or different language has been adopted with respect to other industries. For example, the wind energy industry. And the suggestion that we received from the Office of the Attorney General was to use that model instead, where these minority participation goals would be tailored to the individual license holders.
Was that clear enough, Delegate Rose?
Thank you.
Thank you.
Basically chops up the money.
All right, it's been moved in second. All those in favor, please vote by saying, I'll show of hands. Any opposition? I see a body. Delegate Buckle, rather.
Now, Edith, we've been.
I know. It's late. Thank you very much. It's unanimous. Thank you so
I'm
much.
just moving aside so as to let Delegate Rose or Delegate Hornberger, when they have questions, get more in your screen. Thank you.
No, I'm just kidding. All right, thank you. So I
What's up, ma'am?
thank the collegiality that's being displayed tonight, because I know it's late and but you're hanging in there and I appreciate it. You will appreciate it tomorrow when we have most of this done. All right, collective bargaining requirements. I think we had a discussion regarding language.
Yes, so this amendment basically is clarifying language concerning the labor peace agreement.
George, was there anything else you wanted to add to that?
Sure. This generally indicate that it would exempt those applicants for licensure or licensees who are already have a collective bargaining agreement in place.
Okay.
That would effectively continue to apply. And it would also make clear that the labor peace agreement that required under the bill would apply to all the operations that are conducted by the applicant or the licensee at the facility or the location where sports wagering is conducted.
Okay, great. Delegate Barnes, did you move the amendment?
Yes.
Quick question, Madam Chair.
Yes. Delegate Hornberger?
In terms of the casino, is it mandating that the casino in its entirety have a collective bargaining agreement, or just the staff that will be dedicated to the administration of the gaming license?
So I think in the case of the casinos, they already have collective bargaining agreements, and so those would control.
I don't think all of them do.
They were required to have labor peace agreements.
Okay.
Original casino legislation.
Qualifier. Okay.
So this is really clarification.
Okay.
Delegate Buckle? Delegate Hornberger?
Well, just we're trying to discern between discern between that agreement and a CBA, which is.
I was trying to explain that, and George can correct me if I'm wrong to my colleagues, a labor peace agreement does not mean that you have a union, an active union agreement. It simply means essentially that you have done nothing to unlawfully discourage or prohibit potential unionization on your premises. It's not the same as we actually have a union.
That's correct.
Right.
Okay.
Thank you so much, Delegate Buckle, for that additional clarification. All those in favor of the amendment, please vote by saying aye.
Aye.
Or
Yeah,
show of hands.
sure.
Those opposed? And again, it's unanimous. Okay, we're back to sports wagering with a focus on Pimlico.
Yeah, Madam Chair, before I do the Pimlico thing, let me insert an additional amendment here. And it's something that I think I had discussed briefly with George, but we had some definitional issues. So I'm just going to do it verbally. I'd like to move that we allow an entity that is operating on land owned by the Department of Natural Resources to bid on a Class B license. That would essentially be clarifying language that would give an entity at Fair Hill the opportunity to bid on a Class B license if they so chose. They would still have to compete with everyone else, but they would not be prohibited from bidding just because they're on Department of Natural Resources land. So I'd make that.
Well, thank you very much.
Second that, Madam Chair.
I thought you would. Thank you very much for that amendment. Any discussion? All right, all those in favor, please raise hands, please. Any in opposition? Once more, it is unanimous. Thank you.
So Madam Chair, I'll do the Pimlico one now. So under the sports betting that Pimlico is allowed to do under the existing bill, they're only allowed to do it on racing days. As you may recall, our committee put through a significant bill on the redevelopment of Pimlico last year. And one of the conversations there was attempts by the authority and the city to make Pimlico into an event space. So I would move that we allow sports wagering to be conducted at Pimlico, not only on live race days, but also on days in which an event with 2,000 or more attendees is held.
All right, what was the last part?
Question.
How many attendees?
I think it's 2,000 in the amendment.
Okay.
I think Delegate Attar has her hand up.
Delegate Attar.
Thank you, Madam Chair. I don't have any questions, but if I may have some comments. I want to first thank the Speaker, George Butler, and everyone involved who's been working tirelessly on this important bill and ensuring it's drafted in an equitable fashion. There's so many crucial aspects to it, and I'd like to touch upon one of those, which is Pimlico. And as Madam Chair mentioned before, we are all advocating for our districts. As a delegate who represents Pimlico, I want to thank the House of Delegates for continually ensuring the revitalization of it, just like Delegate Lukey just mentioned. The community surrounding Pimlico has been neglected for so long, and I'm grateful we are continuing to move in a positive and reassuring direction. I have been in many ongoing discussions to ensure Pimlico is on the same playing field as the other racetracks and as sports betting all year round. I appreciate the subcommittee is moving closer to that with this amendment, which adds special events at Pimlico, and I'm pleased to have made headway with this. Pimlico is an extremely important asset to District 41, Baltimore City, and the state of Maryland. I will continue to work with my colleagues in leadership in both chambers and conference committee to ensure Pimlico is treated like the other racetracks and has sports betting all year round. I once again thank all those involved and this subcommittee for the support of Pimlico and the time and effort spent on this very important bill and this amendment. And I plan on voting yes on this amendment.
Thank you very much. And thank you for bringing up the plans for Pimlico. I'm really excited to see what's going to happen in the next few years. Thank you for your comments. Anyone else?
Delegate Holmberg, I had a question, Madam Chair.
Delegate Holmberg, thank you.
Just very quickly, does this put Timonium and Pimlico in a similar posture in terms of operations?
Pimlico has an unrestricted Class A license under the bill.
Okay, and then
Timonium, I misspoke. It's late. Timonium has an unrestricted Class A license under the bill.
Okay, and then Pimlico would have race day only.
Pimlico had
And
race days only under the original bill. This amendment would also give Pimlico the ability to run sports betting during special events. Like concert,
Okay.
community events, things like that.
Yep. Okay, if I could, I'd like to second that.
Okay, thank you very much. All those in favor, please raise your hands. Thank you. Any opposition? Oh, look at that, 3 hands. All right, thank you very much. Let's see. Mobile licenses, clarification with it.
Madam Chair, this is another clarification regarding mobile licensing.
This is merely a technical amendment, Madam Chair and
Okay,
committee members, simply streamlining some terminology that's used in this section. There's no substantive effect.
okay, great. And we're back to prohibited wagers.
Madam Chair, if I may interject,
Yes.
I don't believe you entertained a motion on
Oh,
the
I'm
technical
sorry.
amendment.
I'm
So
sorry.
move.
Second.
It's been moved in second. All those in favor, please just raise your hands.
Aye. Oh, sorry.
Okay, thank you very much. It's unanimous once more. Okay, when we consider the state lottery,
Yeah, I can jump in, Madam Chair.
commission, yes.
So this amendment, under the bill as drafted, an outside party is allowed to make a request that the State Lottery and Gaming Control Commission prohibit a certain type or form of wager. And this was intended to allow, for example, if a sports league feels like a certain type of wager undermines the integrity of their sport, they could come to the Lottery and Gaming Control Commission and ask for the commission to ban that type of wager. It would be up to the commission. What this amendment, all this amendment does is it would require the commission to hold a hearing on one of those types of requests before they grant it.
Okay, great. Any questions? Did you move the amendment?
Move the amendment.
Delegate Smith.
Delegate Smith, thank you.
Yeah, I just have a quick question. Once someone requests from the lottery commission, kind of poses a challenge to the wager and that triggers a hearing, is there an amount of time by which from the request to the hearing happening?
I don't think it's specified in the amendment or in the bill, but I assume it would be specified in regulations that the commission
That would be
adopt.
attended later. Okay, that's the only thing I was wondering about, because people, I didn't want people out here like forever, like, when am I gonna get
Yeah.
to this? Okay, no, thank you. I appreciate
I
it.
will say, I've dealt with a lot of state agencies. Lottery and Gaming Control Commission, I think, does a fairly good job scheduling hearings in a timely manner and
Right.
allowing for public input. So.
But like you said, regulations could handle the nitty gritty of that. Okay, that's all. That's the only question I have.
Very good question. Thank you, Delegate Smith. All right, all those in favor, please show of hands. Okay. It is once more unanimous, and we have an administration. This is a technical, a clarification amendment.
Yeah, Madam Chair, this would simply conform sports betting, the process for remission of share of proceeds from the comptroller's office on sports betting to be similar to what we use for VLTs and table games in regards to loss carry forward. So this essentially does loss carry forward for sports betting.
And your vote for the amendment?
If I may
Please.
speak to the amendment, Madam Chair, part of this was to clarify that only the state's share of the proceeds, that 15% or 17.5%, depending on which provision is operative, would be remitted to the comptroller. In addition, there was concerns raised regarding in the bill, those amounts were to be remitted daily. That's a frequency that probably is not appropriate for the industry. And so instead it was suggested that might be done on a monthly basis instead. This amendment would accomplish that.
Move the amendment.
Second.
All right, it's been moved in second. Any questions, discussion? All those in favor, please raise your hands, please. Okay, again, unanimous. And coming around once more to looking at problem gambling and unclaimed wagers.
Yeah, Madam Chair, I move that the proceeds from unclaimed wagers be distributed to the Problem Gambling Fund. Rather than funding the bill to make sure the Problem Gambling Fund has adequate funding.
Okay,
Did that happen a lot?
Yeah.
and the amendment? Can you move the amendment?
I move the amendment.
Second.
All right, thank you very much. Any questions, discussion? Again, all those in favor, show of hands. It is unanimous once more. And we're almost through. Requirements for NBEs as relates to annual reporting.
So Madam Chair, this amendment requires sports wagering licenses to be reported annually to the Lottery Commission, Lottery Gaming Commission, requiring number of minorities and women owners and employees.
Okay. Can you move the
So
amendment?
moved.
Is there a second?
We'll move it.
How is this?
Was there a second?
How is this one different than the last one we did? Was the last one an affidavit for when you apply, and this is requiring you to produce the same information on a rolling basis?
That is correct, Delegate Buckle.
Okay.
And this is once again similar to obligations that are imposed on medical cannabis licensees.
Thank you very much. Any other discussion? All right, it's moved in second. All those in favor, please show of hands. Okay, thank you. It is unanimous. And
The SWORT. So
yeah,
Madam Chair,
relationship, right?
right, so this provides the members of the SWORT may not have an official relationship to an applicant or holder of a fantasy competition or sports wagering license.
Move the amendment. Is there a second?
Move the amendment.
Okay, any discussion? Okay, it's really self-explanatory. Thank you. All those in favor, show of hands.
I try to make it as explanatory as possible, Madam Chair.
Getting tired. All right, last one we're going to look at tonight requires the SWORT.
Right, so this requires the SWORT to extend permitted by law to seek achieve racial, ethnic, and gender diversity when awarding licenses and encouraging certain businesses, entities to apply for a license. That was a mouthful.
Is there a second to the motion?
Second.
All right, thank you. Any discussion?
Good question.
Question? Delegate.
One last one,
Hornberger.
Madam Chair, is one last one I want to,
Wait,
the
before we do that, Delegate Hornberger had a question.
oh, I'm sorry.
Yep, thank you, Madam Chair. Is there any talk in there about geographic diversity?
No.
Okay.
Language didn't speak to geographic diversity. I think that the geographic diversity is addressed in part by the radius surrounding Class B licenses.
Mhm.
And to the degree that you're revisiting that tomorrow, you know, that discussion has been held over.
All right, I'll hold my comments till tomorrow.
Okay, thanks. All right, did we take, all those in favor? We did this unanimously?
All right.
Okay. All right, and Delegate Barnes, you have,
Yeah, last one, it also has to deal with the SWORT, requiring the SWORT to work as fast as they possibly can to conduct this work.
okay. It's a amendment. Is there a second?
Because I did have that question.
All right, any discussion? All
Work
those
as
in,
fast as they possibly can. I mean, are we giving them some sort of deadline
Six
or?
months.
My
If there's-
experience, we work as fast as they can, whatever you want, as fast as they possibly could.
Right, yeah,
Okay.
and just, can I follow up? Because I
Sure.
did have that question. Like, what's the timing of the application process? The approval,
The
the award, and are we going to, for those who are just kind of patterning this after, and Delegate Barnes will understand, on the federal level, if you put in a proposal to win something and you lose, and I brought this up during the medical cannabis as well, is there going to be a debriefing to the entities that applied and did not win? Are we able to give somebody so that, after the initial 5 years, they kind of know lessons learned and are able, and is there going to be an appeal process? So can somebody kind of walk me through the timeline, how we're going to get this started, executed, and then answer the debriefing and the appeal process, if we can address those two items?
George? I know that was a question, I believe, that Delegate Buckle had, part of the question he had regarding the timeline.
Sure.
Right.
I think that I don't think that anybody is going to be dragging feet with respect to implementation of the statute. I think that all the parties or all those charged with respect to lottery and gaming, the Application Review Commission, once it is appointed, the certification agency, Governor's Office of Small and Women Business Affairs, and the Office of the Attorney General will work together to review the study, develop any regulations that are necessary with respect to the application process to begin implementing sports wagering in the state. As to exact timelines, I cannot provide you an exact timeline. That said,
Sure. And
things did move fairly expeditiously with respect to the medical cannabis procedures with respect to the 2018 legislation. In addition, with respect to regard to appeals, I was going to point you to subsection N, which is on page 32, which would allow review by the State Board of Contract Appeals, and those proceedings would take precedent on the board's docket and heard expeditiously. And I hope that is responsive to both your questions.
Prioritize the courts. Yeah, it is, George. I mean, I appreciate you can't, say, hey, this is exactly how it's going to work out from your perspective. In the interest of the fact that it's over 8:00 at night and this is pretty generic language, I think we'll all support the language, but I would like to say that we want to continue the discussion over the next year where the committee releases the bill to see if we can come to some agreement about putting more defined deadlines on here, because we're doing this because we all understand we're a couple of years behind our neighboring states that already have up and running in their casinos, for example, and mobile applications. And so one thing I would really like for us to think about is, we've got moving parts of who's going to get the Class Bs and maybe who's going to get the mobiles, but the people who we're designating in the bill are going to get the automatic licenses, assuming they comply with the technical commission. I think we should really give some thought going forward to getting them up and running as soon as possible, so that we don't lose another year, so to speak, to our competitors and allow the industry to develop. So I don't want to take any more time. It's after 8:00 at night. We'll vote for this amendment, but we're just saying we may have some further ideas about installing some real timelines.
And just to
I
piggyback on that,
appreciate that, yes.
just if I could
Delegate
follow. I do think that a debriefing part of this process, I think, would be valuable, especially with, those who do not win. If they are provided a debriefing about how they scored or where they fell short, I think that could maybe head off some litigation, because that's how the federal government operates. So that's just food for thought. Just to throw that out for further discussion.
I appreciate
tonight.
that. That was the last amendment. But you're absolutely right. I appreciate your ideas. And Delegate Buckle, we will certainly understand and anticipate a more definitive timeline to be specified. Okay. Any other discussion?
Madam Chair, Delegate Smith had a question.
Oh, that's right. We didn't vote on this.
Didn't want to like belabor
Delegate
things. We just, thank you, Madam Chair. Just quickly, just to kind of echo a bit of what we heard. I know that the bill as drafted would require the Lottery and Gaming Commission to subsequently provide, I believe, either on an annual or some other timeline, a report of kind of the status of the industry, but there isn't a comparable requirement that this commission that is established just for the allocation of the licenses, is similar to what Delegate Rose was mentioning about debriefing of people who do not get licenses. I think as a legislature, we should get some sense of overall, not just on a one-off basis, how decisions were determined, what that looked like in a concise place, because right now we only have the responsibility for report outs after the cake has been baked and eaten, which is, a little bit different. That's once the industry is live. We don't have anything in the interim to describe how decisions were made and licenses were allocated. So I think maybe an amendment tightening that up or adding that in would be helpful.
Absolutely. Very good ideas. Excellent ideas, in fact. I too, you should do consulting for the federal government.
Madam Chair, I second Delegate Barnes's last motion. I don't believe you voted on it yet.
Correct. You're right. All those in favor of the amendment, of the motion, please. Sure.
Aye.
All right. It is once more unanimous. And I just want to say thank you very much for hanging in there. We have made a major inroad in terms of House Bill 940. And we may be meeting again. We probably will be meeting again. So stay tuned. And thank you all so much for being here tonight, for those who are stakeholders on YouTube. And I certainly want to offer thanks to George Butler, the analyst, and for Crystal Medley Green, my chief of staff. And any announcements? Now tomorrow.
Madam Chair, I assume we're going to meet tomorrow to finish up to try to get done by the Friday voting session.
Tomorrow at 4, we will have a meeting. We'll have a reprint of what we discussed today, and we'll hold the amendment conversation until tomorrow as well. So again, have a good night's rest. Don't eat too much pizza, and we will see you tomorrow in the subcommittee at 4. Thank you again.
Madam Chair.
All right, guys.
Thank you for your leadership.